operative page at 34.
No, my lord. Lordship may kindly the page 33.
Yes.
Paragraph 18.
Hmm.
Sorry, I am reading from paragraph 16. Coming to the issue of long incarceration, it is seen that the petitioner is in custody since last more than 1 year, 8 months since the date of arrest. But it cannot be denied that out of 16 number of witnesses, the prosecution could examine 13 number of witnesses within a period of 1 year, 8 months of his detention. Thus, the case is also progressing in a good pace, and it cannot be held that there is inordinate delay in the trial of the case that influence the right of the accused petitioner under Article 21 of the Constitution of India. So, to that effect, considering the substance, learned PP has delayed two citations of the Honorable Apex Court, wherein it is the crux of the judgment of the Honorable Apex Court is that the accused cannot be granted bail solely on the ground of period of incarceration undergone by the accused. It was further held that the accused cannot be granted bail on the sole ground to delay in conclusion of the trial without taking into consideration the allegation made by the prosecution in regard to the existence of prima facie case. Gravity of the offense and the allegation of tampering with the witnesses by threat and inducement when on bail.
Now, it seems that it was rejected because
Considering the long
considered the
incarceration.
progress of the investigation. Sorry,
Long incarceration.
the 16 witnesses, 13 has already
Yes,
been
yes.
examined.
Yes.
Were already been examined. So these are the considerations. So that was there.
So-
Now, what is your new ground?
Now ground is the ground. Actually, his arrest was illegal, not following the actual norms of as mandated in Article 22, subsection 1 of the Constitution of India.
So now you are on the ground of
Grounds of arrest.
challenging.
It is not only new ground because it was already considered lot. In rejection
I have
order, second rejection order.
I have already
It
read
was
out
already taken lot.
Second rejection order was on
It was on
6th
lot
8.
6-8.
6 lot. It has already been taken, this plea lot. And
But that
your
was not-
lordship has already taken view of that and rejected lot.
What was the view? Kindly read out.
The view I will read out. In para 15 lordship, page 32.
Yes.
It is a fact that the present accused petitioner is in custody since long more than 1 year, 8 months from this date of arrest, since 28/11/2023, and it is also fact that there is no detailed prescription of the offense alleged to have been committed by the accused in the notices issued under section 50 lot, that is the 50 lot, and 50A, that is the SARS lot, CRPC, as well as in the arrest memo. But from the submission made by the learned additional public prosecutor and from the materials in the case, that it is very much evident that the entire contraband was recovered from the conscious position of the accused petitioner, and that part of the accused petitioner was also led the investigating team to his house, where from also some contrabands were recovered in his premise. So considering this aspect of the case, it cannot be held that the petitioner was not aware about the grounds of arrest, specifically stated, lordship, or he has not aware about the offense which is alleged to have been committed by him, lordship. So it has already been taken into account, lordship.
So far as the submission made by my learned friend, this honorable court come to conclusion that grounds of arrest, it was I have a knowledge of my grounds of arrest, but that cannot be because that view is not acceptable in view of the honorable apex court order passed in this case, my lord.
And moreover, 16 witnesses has already been examined, lord.
How many?
16,
Already examined.
lord, already examined.
My lord,
That
I am
is,
not.
Lordship may look into that, lord.
PW is closed. Lord.
PW 16 is
No,
over,
no.
lord.
There are already IO to one. There are two IOs.
Then how many witnesses are there according to you?
16.
16. So there is PW 16 is there, lordship may
That is on record. 16 or 17. It may be. That is on
16.
record. Where is 16?
Now your this
So far as my
You are
state,
relying this. Yes.
yes.
Which para?
Paragraph,
Basically-
Lordship, may kindly see page 3 of this order of the apex court, my lord, recent order. Page 3 from the second paragraph.
Yes.
The
They proceed
affected position. That was the part of that case. The proposition laid down by in Povir Purokasta, in paragraph 45. We are of the firm opinion that once this court has interpreted the provisions of the statute in context to the constitutional scheme and has laid down that the grounds of arrest have to be conveyed to the accused in writing expeditiously, the said ratio becomes the law of the land, binding on all courts in the country by virtue of Article 141 of the Constitution of India. Now coming to the aspects as to whether the grounds of arrest were actually conveyed to the appellant in writing before us as he was remanded to the custody of the investigating officer. We have perused the arrest memo, Annexure P7, and find that the same nowhere conveys the grounds on which the accused was being arrested. The arrest memo is simply a pro forma indicating the formal reasons for which the accused being arrested. Next, my lord, with regard to the observation made by this honorable court in last order of this honorable court rejecting my bail application, wherein similar nature of observation was made. So in this context, this observation of the apex court is must have to be taken into consideration, wherein the apex court observed that in paragraph 48, it may be reiterated at the cost of repetition that there is a significant difference in the phrase reasons for arrest and grounds of arrest. The reasons for arrest, as indicated in the arrest memo, are purely formal parameters, these to prevent the accused persons from committing any further offense. For proper investigation of the offense, to prevent the accused person from causing the evidence of the offense to disappear or tampering with such evidence in any manner, to prevent the arrested person from making inducement, threat, or promise to any person acquainted with the facts of the case, so as to dissuade him from disclosing such facts to the court or to the investigating officer. These reasons would commonly apply to any person arrested on charge of a crime, whereas the grounds of arrest could be required to contain all such details in hand of the investigating officer, which necessitated the arrest of the accused. Simultaneously, the grounds of arrest informed in writing must convey to the arrested accused all basic facts on which he was being arrested, so as to provide him an opportunity of defending himself against custodial remand and to seek bail. Thus, the grounds of arrest would invariably on personal to the accused and cannot be equated with the reasons of arrest, which are general in nature. And with addition to the observation of the Bhiyan Kumar is also, there are some elaborate and very much relevant for consideration of this application also. So far as that becomes so far as the trial part consideration, first of all, trial commences after arresting the accused person. So that arrest is also part. After arrest, my arrest trial
Don't think
started.
so. After arrest, trial
After
commences?
after arrest, charge sheet filed. Thereafter, trial commences. So this trial cannot be excluded from the portion from the factum of arrest. It cannot be because after arrest, I come to the domain of law by filing charge sheet and prosecution set in law in motion against me by examining witnesses against the guilt or innocence of the accused person before the learned trial court. But here in this case, my lord, so first factum is that arrest. So when the arrest is illegal, so other part is not sine qua non for consideration. First of all, the prosecution to prove that arrest is not illegal. Trial, I may be acquitted or I may be convicted. That is other issue. But the first of the prosecution, paramount consideration for this honorable court that whether the prosecution succeeded in arresting the accused person in accordance with the law mandated by the Constitution of India or in as per the mandate of the statute or as per the terms of laid down by the honorable apex court in various cases today. That is the main paramount consideration. So far as in rejecting my earlier application, this honorable court has not examined the complete veracity of the arrest. Only proportion, only the number of witnesses has been examined. That was the only main part was considered. So far as my humble submission before lordship, as the petitioner is behind bars since the date of arrest, and whether the materials recorded in the trial court can be a paramount consideration for the learned trial judge whether he is guilty or not guilty, or he is innocent. But at this stage, my lord, I am depriving to consult my lawyer with regard to my conclude remaining part of trial. So which is enshrined in the 304 of CRPC to consult my lawyer improperly. I am unable to consult that. These are the two grounds of this application. So I hope your lordship will consider in accordance with law as per mandate of the Honorable Supreme Court laid down. And apart from this judgment, my lord, in another judgment, Honorable Supreme Court led by former Justice, Chief Justice of India, Gawai, it was a two-judge bench. I forget this name of the parties, but on that 51-page judgment, the Honorable Supreme Court made it very clear that there is no dispute with regard to the grounds of arrest. There is no exception to any other argument with regard to grounds of arrest. If that is not done by prosecution, then the accused is entitled for bail. Other factors are inconsequential. So in that circumstances, my only prayer before your lordship to consider my application by recording any conditions, hard stringent conditions. If I would be convicted, then law will take its own course. If I would be acquitted, then also law will take its own course. An option also remains to the prosecution to do their task in accordance with law.
Because of that, he is not aware of it, so he could not engage advocate.
No, I have not said so.
Okay, but I am stating here, in 2023, when he was produced, he has clearly stated that Harda accused were stated that he will engage lawyer of his own choice. Firstly, Lordship. And
When
moreover,
date what?
date is 28/11/2023. What may look into it.
When he was forwarded to the learned CGM,
What?
that is no considered.
He should, he has given an
Yes,
opportunity to state his grievance, Lordship.
No,
He
no,
should
no.
say that I am not aware of it.
No.
I am not, it is his duty, Lordship. Because that is in the last para, Lordship. Lordship may look into it. He should say before the learned trial court, Lordship, that he is not aware of these things. He has not understood the ground of arrest.
No,
Because
no.
specifically has been asked. No, let me complete.
Do
In
it,
your turn, I have not disturbed you.
do it.
He should have stated before the Honorable Trial Court, Lordship, that he has not been aware of all these type of things. He has difficulty in engaging this advocate. So definitely the court will look into it, Lordship. He has specifically stated that he will engage his own advocate of his own choice, Lordship. He has specifically said, I have given to it, Lordship. And moreover, on earlier rejection order, Lordship, in 6/8/2025, it has been the petitioner for the advocate for the petitioner, he has clearly raised this point, Lordship, in para 8, Lordship. In para 8, he has clearly stated, and he has also cited citations also, which is also reflected the citation, Lordship. That is Vihan Kumar and Puru Kansal, Lordship. These two were also cited in page 30. And after that, Lordship, going through it, Lordship has found it correct that he has been aware of all these type of things, Lordship. He has the knowledge. First, I want to state on that, Lordship. Moreover, there are witness number 7, 8, and 9 clearly implicated, Lordship. Clearly implicated the petitioner that they have stopped. This petitioner's name also they have named, Lordship, and they have stated that in his possession these things are found. And it is also stated that he led to his house, Lordship. And PW16, Lordship. PW16, he is the witness who during house search, Lordship. He also stated that this person has shown these things, Lordship. So definitely materials are there, Lordship. He is also a habitual drug peddler, Lordship. He also from Bihar, Lordship. That also be taken into account, Lordship. And it is from his possession, this thing has been recovered, Lordship. And he has not till now, Lordship, has not shown any that he is possession. He is not in possession. He has not denied that, Lordship. In his whole submission, Lordship, he has not denied that it is not in my possession. That means he has admitted, Lordship.
No,
His statement. So,
sorry, you see the paragraph 6.
so, Lordship, I am stating that it is clearly implicating And it has 16 PW has already been examined, Lordship. It is at the first end of the trial, Lordship. So
Paragraph 6, you read up, see,
paragraph
see, 7.
PW 16 has already been over, Lordship. And PW 16 has already been over. It is in the list, Lordship. And he is the person who has been witnessed the house search, Lord.
Who?
In the PW 16.
No, these are the issues of examination of trial part. Why you are bringing these for the honorable court while
Argument,
consider.
law also I am stating.
No,
That
you-
he should have,
no,
he should have argued.
I,
that-
I have not argued a single issue with regard to the any deposition made by the learned, any witnesses
Now,
before the
see,
trial.
the question is that this 37 is obviously is there.
Yes,
You cannot remove 37 from the statute itself. So from this, what
My lord.
37 says? 37 says it has to be the public prosecutor is to be heard, and whether there is any implications. That is the main issue of the 37 itself.
yes, yes.
So that's why most probably he is submitting
That is right.
in that regard.
Okay.
Because 37 you cannot avoid 37. 37 is already there.
I am not ignoring because
Because it is the statute itself.
under section
37 wherein
37,
37 is there.
sufficient arguments have been made before this honorable court. Because when arrest is in question, then other factors of the case is inconsequential. So far as my understanding, my lord.
Yes, that you have submitted.
And in paragraph 7, my lord, I have stated that he is no way involved with the offence as charged by the learned trial court because being a worker of a pharmacy, he was asked to transport the contrabands from his home, which was stored by the owner of the
What
pharmacy.
is
While
the last order? Last order.
Last order,
he works.
No, 16/10/2025 was the,
Lordship, last order is on 16/10, and it is next date is 13/11/2025.
Ah.
But I am not aware, Lordship, I have not seen the charge sheet, Lordship, because in the causally, the rejection order also, they are stating that there are 16 witnesses. On that basis, I am stating, Lordship. But I don't have the.
I have not gone through. You have gone through.
do you have the charge sheet, copy of the charge sheet?
Charge sheet was in it.
Here you can see.
I
yeah.
have no copy of charge sheet. I have only forwarding
It is on the basis
FIR.
of the submission made in the.
Because we have to
Rejection
see
rejection.
how many
Rejection.
witnesses were listed.
Total number
It says
17.
for 9.
17.
It is 16 for the sale.
যেন একটা IO তো আছে।
The charge sheet was in it.
মানে charge sheet নাই। আপনি তো
That is one.
you have examined. You have examined. You have examined. So far as my understanding, one IO remained to be examined, and thereafter
That's why I'm looking.
other
seeing that.
as the argument is awaited. So in this time, at least 6 months may be required or more than that. So in the
No, no.
meantime,
Where is the next step?
next date, I have no idea.
Next, yeah, but 13/11.
11.
13/11 was the
13
next last date.
Next, last date is 16/10.
16/10.
16/10.
Then 13/11 was
11 is
the as per the next date.
That's for the order. I have gone. Actually, I don't get much time, but I was in another court, Lordship, so I cannot select much, Lordship. But I have looked into it.
It seems then 16 is already examined.
But I also don't know, Lordship, then why.
So far as my instruction, my lord,
This is why I'm looking for the charge sheet, Lordship.
There
How
are-
many witnesses?
there are 2 IOs.
Then status we don't have, no?
Present status only up to that, Lordship, 16/10/2025. It is before the PW starts, Lordship, before it should start.
Why I'm saying, because if you
Because
go by
this is
the recording of statement of PW 16,
Yeah.
it was recorded on this 7/8/2025.
I am to look.
Next, after the rejection order,
Lordship,
it was completed. So
Yes, yes.
16/7/8/2025 already completed.
already complete.
16 witnesses.
Lordship. It is.
Though we have passed the order, it was reported that 13 examined. On that day itself, most probably 13 members were examined. But now it seems that already examined.
Already examined.
So
So I am looking. for
present
how many
status,
witnesses-
I don't know now.
It is charge sheet file in- charge sheet file follow, yeah.
It final police report. It.
Last page, places are not there.
Oh,
Only 2 pages are there, Lord. In the
oh.
place where that is the difficulty, Lord. I have also looked into it, Lord.
Just see, on 7-8, it was there. I mean, PW 16 was examined on 7-8.
Okay.
Prior to that, PW 15 was examined on which date? We just see.
Okay. It was examined on 7, Lord. In the same day.
Same day. And
Same
then,
day.
then you see the 14.
14, Lord. 10/7, Lord.
Huh?
10/7.
Oh, acha. At the time of this, by passing the order, 13 were examined.
Lord.
That is the correct submission.
Lord.
Huh?
I think it is. 32 এটা আধা আছে, আধা তুই না। Very good.
এইটো
আধা
দেখাওকচোন,
আছে।
তেখেতক এইটো দেখাওকচোন। এইপিনে আধা।
এইটো page টো মই বিচাৰি পোৱা নাই।
16 এ লিখা আছে।
16 is there, Lord.
That means PW complete.
PW complete.
Let us,
So far as my
it is
inspection,
the
my-
case of which place? From?
My lord, it is
This case is from which place?
Baksa, Lord.
Huh?
Baksa.
Baksa?
Amulpur.
Baksa. Then just for the
Update-
status report,
update
just
status.
status report,
Lord.
not more than that.
Lord.
This week it is possible, will it be possible?
yeah, any day.
No, it has to be,
Lord.
if it is possible, if it reaches, then it's okay. I don't have any issue.
I will tell you.
Just status report, we need the just status report, not the scan copy. You know.
First of this, 2nd of December.
2nd of December.
2nd of December, don't keep it on 2nd of December, because why I'm saying, I'm sitting this TV1 bench will be this.
The
this
end
is
of
my
this, any date. End of this,
end of this month.
Hmm.
End of this month, that's what I'm saying.
It would be better, Lord. Yeah.
no, 8, I will not be available.
Okay, then.
End of this month, any day. Let him try.
Lord.
4th.
Of December.
Heard Mr. A. Potteran for the petitioner and also heard Mr. P. Vedansi done it additional 50 appearing on behalf of state respondent. The scan copy of which has already been received. After hearing this submission, we had done a counsel for both sides. It is felt necessary to call for the present status of the case record. Case, and accordingly, registry is hereby directed to call for the present status report of the case.
Name of the trial court may be mentioned.
The registry will do the name. Is the matter you force, no? You're saying
4/12.
court of this. Court.
Name
Okay,
of the trial court may kindly be recorded. Name of the trial court, sometimes it's some
Okay, trial court.
special judge. Bucks.
Special judge,
Special judge Bucks.
special judge Bucks. Special judge Bucks. Chirang,
No, Bucks. The case number may kindly be. Case number,
side about me.
published.
May please your lordship.
Yes, it was an AB. You have received the case diary here?
Lordship, I agree.
But your case is that this 14 is the FIR.
Page 14.
Yes, madam. Here, the FIR lost the branch manager of SIS Cash Service Private Limited. That means their duties that they take the contextual work to deposit the money in different ATM of different bank in the city, my lord. And the present petitioner is the employee under that company, my lord. And present petitioner's duty is that he deposit the money, take the money from that office and deposit the money into the various ATMs. And my lord, they provided the security guard also, my lord, and the vehicle also. And my lord, one thing that whatever the money the present petitioner deposit in the ATM, immediately it shows in the office also at the same time. Because there is a system, voltage system. So suppose 1 rupees I have deposited here, and ultimately the branch manager and the official authority will see what I have deposited here. And they will prepare a routine that today you go in this road, my lord. Suppose from Bhangor to Pathan Bazar road, and like that 10 or 15 ATM is available there, you deposit the money there, and they already fix the money in how much money he will deposit in which ATM. And neither he can access deposit it, neither he can less cash deposit in the ATM. There's a system. And on that performance, my lord, he was doing his duty. And on my lord, 11/12/2024, 11 December of 2024, the branch manager lost the FIR. In the FIR, he's saying that, my lord, that on that 9/12/2024, when the present petitioner, along with other accused persons named in the FIR, they are in same rank, my lord, they came to deposit the money in that particular, my lord, area which was selected for them. And there, my lord, the 14 lakhs rupees, they did not cash, they deposit in the ATM, my lord. And thereafter, the authority, my lord, call him over telephone. Then the present petitioner replied that I have kept it on of the ATM and tomorrow I will distribute it. It is their version in the FIR. But as per instruction of my client, my lord, he said that no, whatever the money given me that very day, I have deposited immediately. It is shows in the voltage also. And next day, I could not go to the office. And my lord, they, my lord, already, my lord, found some shortage of money since long days, my lord. And some bank official person also involved here, my lord. Now, whole the, my lord, history and whole the involvement is trying to, my lord, send in blame his name, my lord. And he's saying that no, there is no system because there is a guard also, and it is the direction from the office. If any serviceman cannot, my lord, deposit the money as per rule, he cannot escape from the vehicle, my lord, because the guard is there and they will communicate with the office. So on that restriction, my lord, after depositing the money, when he will reach the office, then after signing, he will release from the office, my lord. Otherwise, my lord, he cannot escape away and he cannot leave the vehicle at any time from of his own. So there is no system to misappropriate the money. Otherwise, every person will do because very restriction is there, my lord. And on 9/12, when my lord, he completed his duty, my lord, no telephone was talked with him. Unfortunately, next day he was in leave, my lord. And that very day, they prepared this story, my lord, that they have found 40 lakhs short in the FIR. Again, my lord, they have mentioned in second paragraph, that page 15, that 33 lakhs 54,000 was short, my lord. And in one paragraph mentioned that even then, 15 ATMs remained to be audited because that audit was not in front of the petitioner. They did not call him. Without, my lord, presence of the present petitioner, they have audited. They are saying that whether audited or not, I do not know, my lord. And in the day of filing FIR, that very day also 15 number ATM was, my lord, remain unaudited. Even then, they have lost the FIR. So my humble submission, my lord, it is a long days, my lord, pending case, my lord. The last occasion, the Honorable Court was pleased to reject, my lord. That is on, my lord, 27 of January, and almost 10 months is gone, my lord. So my humble submission, my lord, that the Honorable Court may consider the interim bail, my lord. I will, my lord, cooperate the investigating agency, and it opportunity maybe provide me, because without my absence, without my presence, my lord, whatever they blaming, my lord, very problem to answer, because there is a systematic here, and all the, my lord, investigation is depend upon the documentary evidence, my lord. Without document, my lord, nothing can do, my lord. Very restricted duty, my lord. Nobody can left the place, my lord, without, my lord, informing proper way, my lord. So my humble submission today, my lord, at least interim bail me, my lord, allow me, and I will provide my lord, my facility to provide the investigation, my lord, and so that it will be clean, because from whose day it is shortage, and in who was the other duty, and how the money came, and all everything I can reply, man.
I only want to say that, Lordship, because as my Rameswaran has already stated that, on 27/1/2025 it was rejected. I have seen, Lordship, after that, how much it has been there, Lordship. Only 2 pages are there on 6/2/2025, after that, Lordship, and 10/2/2025. And in 6/2/2025, Lordship, it is nothing but the note is there. So nothing, what he has stated, no new ground I have found, Lordship, that we can come up with these things can happen or not. Moreover, the rejection order, Lordship, he clearly stated that his role, Lordship, it has been rejected. And moreover, what I have seen, it's a bird's eye view, Lordship, that the thing is that, Lordship, he has transaction, huge transaction in his account, and his other friends are also there, Lordship, who are also the employees of this SIS group. He has made this connection and multiple transactions there, which is unaccounted, Lordship. How this money has come, because they received 10,000 to 50,000, but the transactions are huge, Lordship. And moreover, Lordship, their CDR also, all that has been seen earlier also, Lordship, in the page 18, Lordship. And learned colleague has stated the role, Mayor is not. Mr. Borua, learned edition of public submitted in this regard that there are sufficient information materials in the case that against the present petitioner, who is an employee of the state SIS group, and his duty was to deposit money in the various ATMs. But during the investigation and from the audit report, it is learned that around rupees 98 lakh has already been misappropriated by the accused petitioner, and the investigation is under and hence he has submitted this petition. So it has been found this material role has been seen, Lordship. He has been, and 61(2) is also there. Criminal conspiracy is also there. He is not alone. His other friends are also there. He has misappropriated. So my humble submission, I want to say this, Lordship, as he is again on the merit, Lordship, because it has already been looked into by this learned honorable court, Lordship. It has already gone, and it has not. I have not seen anything new, Lordship, that we can rely on, Lordship. And I have also nothing to state because it has already been on merit, Lordship. Merit, it has already been stated, Lordship.
One of my learned friends saying that the bail was rejected on the month of January. Till date, no investigation is carried, my lord. There is a good point for the present petitioner. And number two, my lord, the learned friend, my lord, stated that the money is transaction in from his account, my lord. They have, my lord, the capital industry at home, my lord, because he is a, my lord, it is temporary job, my lord. Then whole family member are doing that job, my lord. So only my humble submission, without providing opportunity to participate in the investigation, my lord, my reply cannot be go there, my lord, because all the nexus is there. So many person is involved here. I am the fourth grade employee only. My lord, who is monitoring the whole that transaction, my lord? They may be involved in this case, my lord. Keeping me a distance place, my lord, they are doing this drama, my lord. Very unfortunate case, my lord. Thus, a poor person, my lord, is a fourth grade employee, my lord, he cannot do such type of activity. Because FIR, the day of FIR, they're saying that 14 lakhs was not deposited. Because subsequently, how it is come, my lord, 47 lakhs? Because within the second, the bank knows that how much I have deposited. Because without, my lord, clear, I cannot leave the ATM, my lord. ATM will be closed. Because there is no system, he cannot, my lord, leave the ATM. If any person, my lord, wanted to leave the ATM without confirming and clearance of the deposit, because as the system, it will be locked. The door of the ATM will be locked, my lord. He cannot find out. And even, my lord, to rifle and pistol, two security is also with me, my lord. So otherwise, if very simply a person can go of his own will, my lord, the money transaction that is DP cannot be performed, my lord, because every person is not in same area. So my humble submission, in my absence, they are showing day is going and just they are saying the amount is going to increase, my lord. So I am not praying to the final bill today, because after my lord participate from my side, my lord, if honorable court find that yes, my involvement is there, I cannot reply properly, then my bail will be rejected, my lord.
But Mr. Anuddin Tillaney, counsel for the I also heard Mr. Vikas Tillaney, the defendant PT, being on behalf of state respondent. CD received. That, however, after hearing this submission from both sides, and this both sides and on perusal of the case record, it is seen that the last order of rejection was passed on 27/1/2025. And though, as per the report of the IOD, investigation was under process, but surprisingly, it is seen that after 27/1/2025, there is no such progress in the investigation of this case and investigation of this case. In view of this, the case and does the case diary also not update? In view of this, the IO is hereby directed to receive back the case diary and with a and will furnish updated case diary before this court if there is any progress in the investigation in this case. Let the updated case diary be accordingly called for. Matter may be listed. What I'm saying, there was a note in the earlier I have seen that the matter is still under progress. That is very surprising that after 27/1 there is no such progress in the investigation. So obviously Mr. Uddin is submitting properly that may be one of the reasons. So that's why we are want to say that what is the progress. If there is no progress at all, then why the people will support? That is the case. So he is submitting in that manner. So that's why we thought that the updated may be called for. If there is no such progress in the investigation, obviously there may be a case. Okay.
But my lord, I will
Then
provide opportunity to participate with the investigation.
did the matter be listed? এই next কথা আমার দেরি হয়ে এরপর পাঁচটায় করতে আপনার ডিবি 1 থেকে সময় পাউন দেরি হয়ে যায় ফিক্স করাই আছে 11 month 10 or 11 we can 11 for update. Now see, Mr.
Madam,
Uddin,
did the
I have
victim-
rejected your application considering the gravity of the offense because it was not a case of 14 lakhs. It was a case of 98 lakhs after the audit. So there was these things were going on. Now we have submitted that he cannot do such thing because he was under the surveillance, or definitely there was a system as you have submitted, which will definitely bring the authority to know that whether it was deposited or not.
Yeah.
But the question, in spite of the fact that there was the 14 lakhs was missing, and as per the audit report, it was 98 lakhs. So I do admit that there may be involvement of the other bank officials also that cannot be denied. But as you have already rejected your petition, interim may not be
My lord,
granted.
if the honorable court do not provide me to participate in the investigation, my lord, then from one-sided investigation will be there, because my presence is very much important there. Because whatever the question will asked by the investigating
Your
agency, the
presence is
police, my
not
lord,
only required, your custodial interrogation is
well,
required.
documentary evidence,
is
my lord,
the-
here. All the
All
my lord,
things will come out
investigation
only after your
documentary evidence. So,
custodial interrogation.
for a particular time, my lord, if
That's
they
why
found my
custodial
involvement,
interrogation
the
is
case
not
will be
required.
rejected, my lord. For the
Once
time being, my
rejected,
lord.
we cannot
Otherwise, my lord,
proceed.
fair investigation may not be come out, my lord.
Okay,
Only
we have
for,
fixed it on 11. Sit to
11th, you know. Then one. 11. Real good.